Hello students and welcome to the lecture. So students, as we know that we have started the discussion over the union territories in the previous lecture, right? And basically within this particular topic of the union territories, all these are the topics that we had scheduled for the discussion, like starting with the introduction part, thereafter creation of the union territories, thereafter evolution of the union territories, thereafter the state versus union territories, thereafter the union territories classification in India, thereafter the administration of union territories, thereafter the special provision for Delhi, then the advisory committee of union territories. Okay, so these all were the topics that we had scheduled for the discussion. If we talk about the topics that we have covered so far, so basically we have done with the introduction part, and the topic on which we were discussing on that was the creation of union territories. The topics that we are left with, these are evolution of union territories, state versus union territories classification in India, administration of union territories, special provision for Delhi, and the advisory committees of union territories. So this is the picture that we have created so far altogether. I hope that you have revised the previous lecture in the well enough manner before you have come for this lecture. As many times I have told you, that is for your own benefit. Okay. So let's start this lecture. So basically in this lecture, that was the last thing that we had discussed. That was the union territories have been created for the variety of reasons. And these reasons could be political and administrative consideration, like the Delhi and Chandigarh was created on this behalf. Cultural distinctiveness, on this Puducherry, Dadar and Nagar Haveli, and Daman and Diu was created. Strategic importance, the Andaman Nicobar Islands and Lakshadweep was created for special treatment and the care of backward and tribal people. Mizoram, Manipur, Tripura, and Arunachal Pradesh created. Okay, but we know all these got combinedly become the states. Okay, now if we move further in this, then we can have this one. That was the year of 2019. The erstwhile state of Jammu and Kashmir was bifurcated into the two separate union territories, like the same I had told you in the previous lecture also. And these newly created union territories were named as the Union Territory of Jammu and Kashmir and the Union Territory of Ladakh. Okay, so while introducing the Jammu and Kashmir Reorganization Bill 2019, on the basis of which this bifurcation took place, the central government gave the following reasons why they were creating these two new union territories by bifurcating the state of Jammu and Kashmir. First reason, the Ladakh division of the J&K has a large area but sparsely populated with very difficult terrain because it is a highly mountainous area, and there has been a long pending demand of Ladakh people to give it the status of union territory so that the central government could focus on this part and could realize their aspiration. So the union territory of Ladakh will be now without a legislature so that the central government could directly focus on this state. Second, further, keeping in view the prevailing internal security situation, like the terrorism and all, fueled by the cross-border terrorism in the existing state of Jammu and Kashmir. We required a separate union territory for Jammu and Kashmir, okay? And the union territory of Jammu and Kashmir will be with the legislature. So we can say that basically some of the civic matters would be taken up by the local state government, but majority of the portion will be taken over by the central government directly, so that the government could have direct access and control over there. Now, if we talk about the evolution of the union territories, like how does the union territories got evolved over the period of time. The Constitution of India that was adopted in November 1949. Now, most of you will say, if the November 1949 was the year in which we adopted the Constitution, then why do we celebrate 26th January every year as a Republic Day, and why we consider 26th January 1950 as the day when India became Republic? Simple answer is that in November 1949, basically the Constituent Assembly that was created for the creation of the Constitution, that assembly adopted the Constitution of India. Okay, and because on 26th January 1930 we realized our complete independence as the goal. So that's why we implemented the Constitution on 26th January 1950, and we celebrate 26th January 1950 as an Republic Day every year. Okay, so this Constitution initially divided the Indian states into the 4 categories. Okay, like Part A, B, C, and D. We know Part A comprising the Governor General provinces, Part B comprises the provincial state with the legislature, Part C comprises the Chief Commissioner provinces, and Part D alone having the Andaman and Nicobar Islands. Okay, while the sole Part D state was the Andaman Nicobar Islands, that was administered by the Lieutenant Governor who was appointed by the Union government. And thereafter we know that basically this division was ended with the State Reorganization Act 1956, and then the things got divided into the several manners. Okay, like the state and the union territories, and most of the union territories of that time, those got transferred into the state. So first is the 1956 State Reorganization Act of 1956 merged Part C and Part D. The Part C was the scheduled districts governed by the chief commissioners during the British time, and Part D all alone comprising the Andaman Nicobar. These two got merged into a new category that was introduced on that time, which category was known as the Union Territories. And on that time, the 6 Union Territories created, and those were Andaman Nicobar Islands, Lakshadweep, Delhi, Manipur, Tripura, and Himachal Pradesh. Okay, later on, the Himachal Pradesh, the Manipur, and the Tripura, these were granting the statehood title. Then comes the 1961 Dadra and Nagar Haveli, that was previously under the Portuguese rule. Okay, and after the liberation from Portuguese rule, that got merged into India and was made a new union territory. Thereafter comes the 1962. In 1962, Pondicherry, which is now known as Puducherry, that became a union territory. after being transformed from French possession and was granted a state legislature by the Government of Union Territories Act 1963. Okay. Thereafter, in 1966, the Chandigarh was designated as the shared capital of state of Haryana and the state of Punjab. Why? Because 1966 was the tenure when the Haryana got separated from Punjab and established as a new state. But they shared the common capital, that was the city of Chandigarh, that territorial wise lies in the state of Punjab. And because Chandigarh could not be governed by one state government, and the arrival of both the state governments into the same city was somehow difficult. So that's why this became as a shared capital of Haryana and Punjab, but put under the control of the central government because it became as an union territory. In 1987, Daman and Diu, which was formerly a part of Goa, okay, that got separated from Goa and designated as a new union territory. Thereafter, in 2019, Jammu and Kashmir state got a Jammu and Kashmir Recognition Act, and this splitted the state into the two newly formed union territories. The first was the Union Territory of Jammu and Kashmir, and second was the Union Territory of Ladakh. Okay. Thereafter, in 2020, the two union territories of Dadar and Nagar Haveli and Daman and Diu, these got merged into a single territory, and these two are now single one. So Daman and Diu was basically separate from Goa, okay, and then Dadar and Nagar Haveli, which was previously existed, they both were existing as in separate union territories, but later on got merged with each other. All right. So remember this division. After this, now we have state versus union territories. So first feature is the form of government. Okay. So state is a constituent division which is having its own government form. Okay. The union territories are administered and controlled directly by the central government of India. Okay. So they do not have their own government. Federal relationship. The state enjoys a federal relationship with the central government. Why? Because the legislative and the executive powers are being divided between the central government and the state government. Okay. So the central government having its own power and the state government having its own power. Okay. But the union territories are the part of the unitary structure. Okay. And these are completely under the control of central government. All legislative and executive powers resting with the union. So there is no federalism exercised in the case of union territories. Even if the union territories lies within the territorial jurisdiction of any state, still the state could not have any legislative and executive power in relation with the union territory. And all the powers would be exercised by one and only central government. Role of governor or the administrator. The governor acts on aid and advice of the Council of Ministers. Okay, it means that whosoever would be the governor of the state, he or she is required to get the advices and aid from the State Council of Ministers. Okay, the administrator acts on behalf of the president. It means whosoever would be appointed as an administrator of the union territory, he or she will be working on behalf of the president only. Okay. Thereafter, representation in the parliament. If the states are concerned, so we can say the states are being represented in both the houses of parliament, whether it's Lok Sabha or the Rajya Sabha. The state will have their representatives. Whereas, as far as the union territories are concerned, so they got represented in Lok Sabha only. Okay, but here is an exception for Delhi, Puducherry and Jammu and Kashmir, which also have their representation in Rajya Sabha. And how? Because the Rajya Sabha generally having the representatives from the legislative assemblies of the states. Okay, so union territories which are under the control of the central government and do not have their legislative assemblies, they oftenly not have any representation in the Rajya Sabha. But Delhi, Puducherry, J&K, Jammu and Kashmir, these are the only union territories which having their legislature. That's why they could have their representation in the Rajya Sabha. Thereafter comes the Legislative Assembly. It's having its own Legislative Assembly, the states. Union territories does not have its own Legislative Assembly except for Delhi, Puducherry, Jammu and Kashmir. Okay. Thereafter, if we classified the union territories in India, okay, classification. So, first is union territories that having its own legislature, and thereafter the union territories that do not having their own legislature. Okay. So, the first type of that union territory is Delhi NCR and Puducherry, and now J&K is also the part of it. Other union territories are without the legislature. Okay. After this comes the executive. Lieutenant Governor on the aid and advice works here. Okay. Like the Lieutenant Governor of these union territories that having the legislature is now works on the aid and advice of the ministers, Council of Ministers. But in case of without having any legislature, these are administered by the president and the administrator acting through an Administrators Advisory Council and the Home Ministry Advisory Council, HMECs. Okay, so that the people or the member of these councils and the committees could advise the administrators on the matters that are concerning these union territories. Got it? After this comes the legislature. The Legislative Assembly on the state list except the police, public order and land, and concurrent list of the 7th schedule in case of conflict, the law made by the parliament privilege. Okay, we can say that the Legislative Assembly of these union territories could make the laws on the matters that are presented in the state list, but police, public order and land. This is exclusively reserved for the Lieutenant Governor of these Union Territories, and the Legislative Assembly of these Union Territories are not entitled to make laws on this. Thereafter, if we talk about the concurrent list, so if the legislature of these Union Territories have made certain law, on the same matter the Parliament also made a law, then if there is any conflict between the laws, always the Parliament law will be prevail. Okay? And when the Assembly is being suspended, in such a case, the President cutting the power to make the regulations. Okay? Whereas, in the case of without having legislature, Parliament on the 3 list of the 7th schedule could make the laws, and the President of India can make regulations for peace, progress and good governance also. If we talk about judiciary, so Delhi High Court works for the Delhi Union Territory, Madras High Court for Puducherry, Kolkata High Court for Andaman Nicobar Islands, Punjab and Haryana High Court for Chandigarh, Mumbai High Court for Dadar and Nagar Haveli, Daman and Diu, Kerala High Court for Lakshadweep. Okay? And if we talk about the administration of these Union Territories, so Article 239 to 241 enshrined in Part 8 of the Constitution deals with these Union Territories. Okay? Even though all the Union Territories belong to the one category as per the Article 1, like we have seen in the starting, but still there is no uniformity in their administrative system. Okay? Every Union Territory is administered by the President acting through an administrator who should be appointed by him. Okay? An administrator of a Union Territory is an agent of the President and not head of state like a governor. Okay? It means that the administrator will be working on the advices of the President, not by the autonomy as like the governor does. The President can specify the designation of an administrator. The designation could be a Lieutenant Governor or the Chief Commissioner or the Administrator. At present, it is Lieutenant Governor in the case of Delhi, Puducherry, Andaman and Nicobar Islands, Jammu and Kashmir and Ladakh, and Administrator in case of Chandigarh, Dadar and Nagar Haveli, Daman and Diu, and Lakshadweep. The President could also appoint the governor of a state as the administrator of an adjoining union territory. But in such cases, the governor is to act independently of his council of ministers. It means that when he has to deal with the state, he will be working with the different council of ministers. When he has to deal with the union territory, he will be working with the different council of ministers. Thereafter, the union territories of Puducherry in 1963, Delhi in 1992, and Jammu and Kashmir in 2019 provided with the Legislative Assembly and made a council of ministers, and this council is basically headed by the Chief Minister. The remaining 6 union territories do not have such popular political institutions and directly governed by the central government. But the establishment of such institutions in the union territories does not diminish the supreme control of the President and Parliament over them. It means that, however, Puducherry, Delhi, Jammu and Kashmir having their own legislative assembly, but still President and Parliament could exercise the powers over them. Thereafter, the Parliament could make laws on any subject of the three list, including the state list for the union territories. The power of Parliament also extend to the Puducherry, Delhi, Jammu and Kashmir, still they having their own legislatures. This means that legislative power of Parliament for the union territories on the subject of the state list would be remain unaffected even after establishing a local legislature for them. But the Legislative Assembly of Puducherry can also make laws on any subject of the state list and concurrent list. Thereafter, similarly, the Legislative Assembly of Delhi could make laws on any subject of the state list, but not allowed to make laws on public order, police and land, and also the concurrent list. They could make the laws, but in case of conflict, only the Parliament's laws would be prevail. Likewise, Legislative Assembly of Jammu and Kashmir could make laws on any subject of the state list except the public order and police and the concurrent list. Thereafter, the President can make regulations for the peace, progress and the good government of Andaman Nicobar Island, Lakshadweep, Dadra and Nagar Haveli, Daman and Diu and Ladakh. In case of Puducherry also, the President can legislate it by making regulations, but only when the Assembly is suspended or dissolved. A regulation made by the President has the same force and effect as in Parliament Act, and also repeal or amend any act of Parliament in retaliation to these union territories. Thereafter, the Parliament can establish a High Court for a union territory or put it under the jurisdiction of High Court of adjacent state. Delhi is the only union territory that having the High Court of its own since 1966. The Bombay High Court has got jurisdiction over two union territories, Dadar and Nagar Haveli and Daman and Diu. Okay. Thereafter, Andaman Nicobar Islands, Chandigarh, Lakshadweep, Puducherry, these are placed under the Calcutta, Punjab and Haryana, Kerala and Madras High Courts respectively. Jammu and Kashmir High Court is the common High Court for the two union territories of Jammu Kashmir and Ladakh. The Constitution does not contain any separate provision for the administration of acquired territories, but constitutional provisions for the administration of union territories also apply to these acquired territories. Now we have special provisions for Delhi. 69th Constitutional Act of 1991 provided a special status to the Union Territory of Delhi and redesignated it as the National Capital Territory of Delhi and designated administrator as the Lieutenant Governor. Created a Legislative Assembly and the Council of Ministers. Previously, Delhi had the Metropolitan Council and the Executive Council. The strength of the Assembly is fixed at 70 members directly elected by the people. Elections conducted by the Election Commission of India like the any other area. An assembly could also make laws on all the matters of the state list and the concurrent list, except the three matters of the state list, that is public order, police and land. But laws of Parliament prevail over those that are made by the Assembly. Strength of the Council of Ministers fixed at 10% of the total strength of the Assembly. That is 7 Chief Ministers and 6 other ministers. Chief Minister basically appointed by the President, not by the Lieutenant Governor. Other minister appointed by the President on the advice of Chief Minister. Ministers hold office during the pleasure of the President, and the Council of Ministers collectively responsible for the Assembly. The Council of Ministers headed by the Chief Ministers aid and advise. Lieutenant Governor exercise their powers and the function except in so far as he required to act in his own discretion. In case of different in opinion, the Governor and his ministers could refer the matter to the President for the decision, and President could reverse the orders to the Governor, and Governor is required to act accordingly. When a situation arises in which the administration of the territory cannot be carried on in accordance with the above provisions, President can suspend their above provisions operation and make the necessary incidental or consequential provisions for administrating the territory. In brief, we can say, in case of failure of constitutional machinery, the President could impose his rule in the territory. This can be done on the report of the Lieutenant Governor, or otherwise this provision resembles the Article 356, which deals with the imposition of President's rule in the state. The Lieutenant Governor is empowered to promulgate ordinances during recess of the Assembly. An ordinance has the same force as an act of the Assembly. Every such ordinance must be approved by the Assembly within the 6 weeks from its reassembly. He could also withdraw an ordinance at any time, could not promulgate an ordinance when the Assembly is dissolved or suspended. Further, no such ordinance can be promulgated or withdrawn without the prior permission of the President of India. Now we have the advisory committees of the Union Territory. Under the Government of India, Allocation of Business Rule 1961, Ministry of Home Affairs is the nodal ministry for all the matters of Union Territories relating to the legislation, finance and budget, services, and appointment of Lieutenant Governors and administrators. All the 6 UTs without legislature, like the Andaman Nicobar Islands, Chandigarh, Daman and Diu, Dadra and Nagar Haveli, Lakshadweep, and Ladakh, they have the Forum of Home Ministers Advisory Committee, Administrators Advisory Committee, while Home Ministry Advisory Committee is chaired by the Union Home Minister. Administrator Advisory Committee is chaired by the Administrator or the concerned UTs. Member of Parliament and the elected members from the local bodies, example the District Panchayat, Municipal Corporation and the Council, these are present here among with others. The committee discusses the general issues relating to the social and economic development of Union Territories. Administrative systems of the Union Territories at a glance. Andaman Nicobar Islands, Lieutenant Governor, under the Judiciary of Kolkata High Court. Chandigarh, Administrator, under the Judiciary of Punjab and Haryana High Court. Dadar and Nagar Haveli, under the Administrator, Judiciary is under Bombay High Court. Daman and Diu, Executive Administrator, under the Judiciary of Bombay High Court. Delhi, Executives are Lieutenant Governor, Chief Minister and Council of Ministers. Legislature, Legislative Assembly is there. Judiciary is, it is having its own High Court. Lakshadweep, Executive is Administrator, under the Judiciary of Kerala High Court. Puducherry, Executive is Lieutenant Governor, Chief Minister, Council of Ministers, having the Legislative Assembly. Judiciary is Madras High Court. Jammu and Kashmir, Lieutenant Governor, Chief Minister and the Council of Ministers, Legislative Assembly, under the Judiciary of Jammu and Kashmir High Court. Ladakh, Lieutenant Governor Executive, Judiciary is under Jammu and Kashmir High Court. Okay? Remember, the Governor of Punjab is the concurrently Administrator of Chandigarh. Administrator of Dadar and Nagar Haveli is concurrently Administrator of Daman and Diu also. And Lakshadweep having its own separate Administrator. If we compare the states and the Union Territories at one time, so state having the federal relationship with center and Union Territories having the unity relationship with center. States share a distribution of power with the center. Union Territories under the direct control and the administration of the center. States having their own autonomy. Union Territories do not have any autonomy. There is uniformity in their administrative setup, no uniformity in their administrative setup. The executive head is known as governor. Their executive head is known by various designation. administrator or lieutenant governor or the chief commissioner. Governor is an constitutional head of the state. Administrator is an agent of the president. Parliament cannot make laws on subjects of the state list in relation to the state except under extraordinary circumstances. Parliament can make laws on any subject of the three list, the state list, in relation to the state except under relation to the union territories. If we look at the articles at a glance, 239, Administration of Union Territory, 239A, creation of local legislature or the council of ministers or both for the certain union territories. 239AA, special provisions with respect to Delhi. 239AB, provision in case of failure of constitutional machinery. 239B, power of administrator to promulgate ordinances during the recess of legislation. 240, power of president to make regulations for certain union territories. 241, high courts for union territories. 242, Coorg repealed. So students, here we have finished this. Okay, please revise the facts and figures in the proper manner and be ready for the next lecture. With this note, let's end this lecture, and what we say thank you.